Hello, and thank you for joining us on today's Ask Andrew show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the founder of Feldstein Family Law Group. We're a family law firm that's practicing in the GTA with locations in Markham, Vaughan, Oakville, and Mississauga. And both myself and our entire team practice exclusively in the area of family law. Today, I'm excited to have with us one of our senior associates, Daphna Schwartz. Daphna's been with me here at Feldstein Family Law Group for a number of years, and welcome back on the show today, Daphna.
Thank you, Andrew. I'm happy to be here.
So today's topic is an interesting topic, and it's somewhat new, relocating with children post-separation. Now, in my experience, this becomes one of the most difficult and challenging aspects of family law because when somebody wants to move, it is very detrimental in terms of the relationship with the child or children and the parent who isn't moving. So I wanted to dive into that topic with you. And really, this is a show that's about a parent who's considering a move or a parent who is facing a co-parent's decision to relocate. What does the legal landscape look like? And the fact is, it's not easy, it's not simple. And I'm hoping that during today's show, you can share some of your insights into relocation cases. And I'm going to start with a more simple question. What is relocation?
So relocation differs from what we refer to as a simple change in a place of residence. So sometimes parents post-separation, they're moving. House doesn't work out, moving to a different area. The point is that when they're moving, it doesn't impact the parenting schedule. We talk about the parenting schedule when parents are separating. They're going to put in place a residential schedule, meaning number one, who the children are going to reside with primarily. And then what does the schedule look like? So is it going to be a shared arrangement where children are with both parents equal time? Is children residing with one parent primarily? And then what does the schedule look like with the other parent during the week, every other weekend? So that's negotiated, and usually whether it's put into a separation agreement or a court order. So sometimes post-separation, parents will move, but that move doesn't really impact the change in a schedule because they might only be moving away 20 minutes, 10 minutes, half an hour. When we talk about a relocation issue, or sometimes referred to as a mobility issue, we're referring to whether a parent is moving a few hours away or possibly more than that to a different province, international.
Well, Daphna, would you agree with me that if you have a couple with equal parenting time, and let's say they lived somewhere like Oshawa, and one of the parents was moving to Oakville, that may create a relocation issue because the equal parenting time may be impossible to continue with such a long distance for those two people?
Exactly. And that's when this issue comes about, is whether there's going to be an effect on the other parent's parenting schedule and whether that should in fact change and whether that's in the best interest of the child or for the family. So that becomes what we refer to as the relocation, and that starts this process of how we go down that path, okay? Because then there's certain criteria that needs to be met on how we go about that.
So one of the things I'd want people to appreciate, the example I just gave to Daphna, if that was a parenting regime where both parents had equal time, I think that would clearly be a relocation case. But if that was a situation where there was a primary parent and the other parent just saw the children or child from Friday to Sunday, alternating weekends as an example, that may not be a relocation issue because an hour commute on a Friday and on a Sunday probably doesn't impact the parenting time. So there isn't a clear cut rule of distance, drive time, because things can be different in terms of how many kilometers somebody is away from somebody based on whether somebody's in downtown Toronto or somebody's in a more rural area. So I'm saying that because people often want rules, and we as lawyers, we can't give you that there's an exact rule, but what we can say before there's relocation, and we'll probably repeat this a few times, you need to consult with a lawyer to make the decision of whether or not the notice under the act is required. because in some scenarios we may say yes, in other scenarios we would say no. Do you agree with me on that, Daphna?
Yes, so the real issue is when a relocation issue arises, whether the parties disagree on the move. So if there's really no disagreement, there's no relocation issue. And like you're saying, even if that move is only 1 hour, that parent may still disagree, and then that becomes a relocation or mobility issue. And I think that oftentimes when we're consulting with clients previously, sometimes, if your client mentions to you that, what, in time I may want to move, or, I'm thinking about getting a job somewhere else, or I have family in another area. These are things that sometimes you can think about prior, possibly put them into an agreement that you're allowed to move a certain kilometer away that may not affect the parenting schedule. And so these issues don't arise in the future. But that's something to think about beforehand if you possibly know, where what your outlook might look like, in the future. You may not know that now, but if you do, it's good to put that in.
And it's also good because transparency is important. If you're planning on being a co-parent with someone and you want to say, well, I'm going to do whatever I can in order to get the primary residence, so I'm going to say today I'm not going to move. And then a month after the ink is dry on an agreement, I'm then going to say I want to move. You need to realize if we end up in court on that, judges aren't stupid. And most of the time when there's a move, because all of a sudden you magically want to be closer to your new boyfriend or girlfriend, or you magically want to be closer to family, but you said in the first round you didn't want to, and a month later you do, it comes across pretty transparent that you were playing the game of, I'm going to wait till I get what I want and then try to use that new status quo I've created. And you need to appreciate when you lack the transparency and you play a game, I actually think you're hurting yourself rather than helping yourself and putting it out there that you may want to do it. And if the other side disagrees, okay, so they disagree and you may park it and say you want this ability, they don't, and you'll deal with it later. But at least then you've been transparent about the whole topic. And I think when you're not transparent, when you play games, judges know it. So as I move on this issue of relocation, uh, if parties are separated and they have a parenting schedule, how does that affect the ability to relocate?
Well, as we discussed and mentioned before, becomes an issue if the relocation and that move impacts the other parents' parenting time with the child. So if the current parenting schedule, that's important. So if the move, just changes, as we said, a day, if it's a shared parenting schedule, and all of a sudden that move is going to affect that, then that is when we have a
And,
relocation
and
mobility issue.
and people need to understand what is effect, because Daphna said earlier 10-minute drive. I would always say a 10-minute drive, but I put this caveat, is 10 minutes rush hour or not rush hour, because it may take me from where our office is in Markham 10 minutes to get to, or 15 minutes to get to the Don Valley in Eglinton if there's no traffic, but it may take me 45 minutes in the morning during rush hour to get there. And if that's the case, is that going to affect the ability of that schedule to work? Because if the children are with me half time, uh, the kids may be too tired at school now. They have to get up earlier. How about going back and forth all the time for their extracurricular activities and visiting friends? So these are all part of the issues that go into the matrix of what we might consider relocation and what will impact parenting and what won't. And that's why I can't say it often enough. It's not black and white. It can be gray as to whether something is too far or not too far. So I'm saying that to be so people can understand that. Now, how does someone start the relocation process?
So there's very clear now legislation on how it started, and that changed a little while ago. Before it was just, was brought about court application. So now in the legislation, and remember, it's not just, it's not just in the Divorce Act. It's not just, whether you were married and separating parents. There's also the Children's Law Reform Act that guides, parents who necessarily weren't married, or lived common law, or have a child together. So there's now specific guidelines around it. There's notice periods and there's proper forms that need to be filled out. So in the legislation now, I think it's about a 60 days notice. There's specific forms now, so it's not just a standard application, but there's specific notice forms that need to be filled out and provided to the other parent and specifics as to when you plan on moving, where you plan on moving, the reason for the move, and what the schedule, and will it impact the schedule. And that gets sent and served on the other parent, and that parent then has a certain number of time to respond to that. And if the parties can't agree, this is going to get litigated before a judge, and a judge will look at several factors in making a decision.
The key thing there that every viewer has to understand, if you get served with this notice and you don't respond to it in accordance with the time frame that you're required to respond, the other side is then good to move. They don't need to go to court. They don't need to get a judge to do it. You don't need to be served with a court application. So I can't stress enough, when you get that notice, if you're not going to consent to it, respond to it right away. Make sure the other side is on notice, and don't think a response was during a phone call, I told my ex they're not going to move and I'm never going to permit it, because there's no proof of that. You want to make sure you have a written record that you disagreed with it. Best to do it the right way, but even if you have it in writing, it's going to create a problem for the other side if they make that unilateral decision to move. So I can't stress enough to properly put it in writing and say, no, I'm objecting to it, because you may be in for a surprise one day when your kids have moved and you thought you told the other side over the phone that you objected to it. The other thing for people who are victims of domestic violence, there is a process to go to court to get a move sanctioned by the court, but it's a very high onus to do it without notice. There's very, very few cases where it has happened. But don't take on, and I'll say this to every viewer here, do not take on the attitude of, I'm going to go do what I want to do and let the consequences happen later because I'm going to get a tactical advantage by moving first. That's the kind of thing that will really get you in trouble with a court for not following the way things are supposed to happen. Because that kind of self-help where you pull a child out of school and you go enroll the child in another jurisdiction and you tell the other parent, I've moved, tough luck. You have demonstrated to a judge that what you don't care about is the best interest of your child, because you may be forced to move back and move the child back into the school. That's not thinking about your children first. That's thinking about yourself first, just because you want to end up somewhere. There's a big statement that makes to a judge. So I can't emphasize enough two real points for people here as takeaways. One, don't do self-help. And if you are a victim of domestic violence, I'd strongly recommend you speak to a women's shelter, you speak to divorce lawyers, and you make sure that if you're going to do that move without telling the other side, you do it the right way, which is sanctioned by a judge in advance of the move. The other piece that I would say to people when they receive these relocation notices and you don't agree, object to it, and object to it right away. And don't let things go to the deadline where you're cutting it really close within a day or two, because sometimes life may get in the way and you may somehow forget. So just don't make that mistake.
Yes, I completely agree. And I think if you're going to do that, I always tell a client, you can't just, move and tell them after, I've moved and this is in the best interest of our child, because that other parent is likely going to bring a motion for the return of the child to where they're residing beforehand, and likely be successful on that, especially if there's a shared parenting schedule in place. The judge is going to look at whether there is an existing court order, an existing separation agreement in place. And if there is, and the parent chooses to move without the other parent's consent, likely that's going to set a bad precedent from the beginning, and that order will be made, and they're probably going to have a very hard time then, with that move going forward and getting an order to do that.
Now, what are the factors a court will consider in a relocation case?
So in a relocation case, the main thing that courts are looking at is what is the impact on the child and what is the best interest of the child. Sort of looking at, when we're starting a schedule from the beginning. There's other things that a judge will look at is the reason for the move. So what is the reason? Is it to be near family? Is it a change in school? Is it maybe a parent has a new job? Um, is it to be near family? There's a reason for the move, but the question is whether that's in the child's best interest for the move, not just on the parent who wants to move. Is that in their best? It's for the child. Judges will also look at the views and preference of a child. That's not the determining factor, but especially if children are older, 13, 14, 15, a judge will look at their views and preferences on whether they wish to move as well, and how that will impact them. And so the judge will, it's not specific. Every case is fact specific on its own, but there's a slew of factors that are looked at, and the judge will look at all of those factors in determining to make a decision on whether that's in the best interest of the child and how that affects the parenting schedule and how that affects the child's relationship with the other parent who's not moving, and can they still have that meaningful relationship with the amount of time they're going to spend if it's determined to be in the best interest of the child, especially if
Well,
there's a shared schedule.
well, and the interesting thing you need to appreciate, there's factors to look at for what is in the best interest of a child. But sometimes it's what may be, and you might say, as Daphna said, it's not the best interest of the parent. But there are cases that talk about what's good for a parent may also be good for a child. So, for example, if I have an unemployed parent who's a primary caregiver and now they've been given a fabulous job opportunity with an increase in pay, well, it's certainly in the best interest of the child to be able to have food on their plate, to eat, shelter over their home, have a parent providing a good role model of working. So there's a lot of things you can see in that. And that can be an important part of it. There's also the connection to siblings and second relationships that can be important. So sometimes, some of the hard cases are somebody repartners. And when they repartner, they find out that there's a mobility issue because they want to go live in another city, another country with their new partner. And when you're the other parent who is staying in the same location, that becomes really hard to accept because you're being told that my child is going to move to another city or another country because of somebody who's not their father that this woman has chosen to live with. But there's roles in that. And I remember there's one case with an executive at Microsoft who had a great income. And you don't want to upset that potential great income. Like, how do you deal with it if you have a payor who, let's say, makes $50,000 a year and pays very modest child support, and the recipient has now repartnered with someone who makes $1 million a year but wants to move to a different city? Certainly, is that lifestyle that that child is going to have in that new partner's home going to be significantly better? It will be. It will be in the stability, and maybe there's extended family in that city, and that's how the person met them. So I'm saying this because, like what Daphna's saying, nothing is a clear cut tick mark, tick mark, tick mark, ergo, I'm going to win. A lot of it boils down to different factors and how you present them all and how you put them together for the court. And one of the things that we'll see when we deal with lawyers that don't just practice family law and dabble or self represented people is they will pull out the legislation and say, aha, look at this one point in the legislation. We practice part of our interpretation is of legislation and what we think will happen in a yardstick in court. For me, it's my 31 years of experience of doing this. I've been at it for 31 years. I have a gut feeling when I see a case as to whether I think it's going to work and not work. And that's part of what you're paying for in a lawyer. So if someone just says, well, I'm living in Toronto, I'm not happy now that I'm divorced, and I want to go move to Vancouver because I want to live closer to the mountains and want to live on the ocean, that's good. That's a loser. And that's going to lose every day of the week. But some people will want to say, but it's in the best interest of my child to have a great life where we're going to be able to live closer to the ocean and I can take my kid to the beach every weekend in the summer months. Okay, that sounds good. But is that really better to take your kid to the beach than it is for your child to have a relationship with the other parent? Because that's what the question is. And that's where some people lose focus and don't appreciate it. Now,
Yeah.
the other piece that we get into, Daphne, as you've mentioned, meaningful relationships can be maintained. So if somebody wants to move with their child somewhere that is a great distance, how do you maintain that meaningful relationship?
So we've had cases like that. I actually had a similar case to this where the parent, I think it's a question, as we said, is how much time the other child is spending with that parent. And so I had a case where, a parent was not paying, and that was one factor. A parent was not paying child support, and the other parent was offered a position somewhere, which, could get them good income and a better lifestyle for the child. And, we determined that that would be in the best interest of the child. And the question was, is we're talking, it was a distance of an airplane distance. Okay. So there's a difference of, is it a driving distance? Is it you got to get on a plane to see the child? So how do you maintain that? Well, we have holidays, we have summers. Is it that the other parent is willing to bring the child, on a flight and to spend a week with the child? Is it during the summertime? Maybe they're coming back with the other parent for 2 months. Maybe the agreement is that to maintain that meaningful relationship, they're going to spend a month or two with the child. Can the other parent possibly, drive to where the other parent now wants to live and maybe spend a weekend there? Can they come over there and spend a few days? So we're always looking at holiday time. There is long weekends that is available for the child, Christmas break. And so the question is, and it could also be a question of funds. So if the parent is moving, are they going to pay for that? Maybe they're going to pay for the other parent to come and drive or to take a plane ride in order to maintain that relationship. I think it's a question, as we said, maintaining the relationship, how much time that is, and can you sort of make up that additional time? Maybe it's not, as we said, a shared parenting schedule. Maybe it's that they're having, every other weekend, or maybe they're having, 3 days a week. And so that additional holiday time, long weekends, vacations, maybe that will make up the time that the child can then, spend with that other parent to maintain that
Well,
relationship.
the key part and the key takeaway for people is be creative. And if you want to move, be generous with the time that you're proposing. Don't be limiting. Don't try and squeeze every last penny of child support because there may be a significant increased cost in accessing the parenting time that may need to be offset against child support. And be prepared that, like Daphna said, during the summer, you may get only a week or two of summer vacation with your child. The other side may get every March break. The other side may get the bulk of the Christmas break because these are the places you can make up for it. And I can guarantee you that if you're successful in either convincing a judge of the move or you're successful in negotiating a resolution, you may hate the summers and want to blame your lawyer, but you may not appreciate had you not made that concession, you may not have been successful because that's a central part of the test. And the other thing, if you're the one who wants to move, build in regular set FaceTime or other type of video parenting time with the kids. I mean, part of it is the age of the kids too. The older the age, you're not really going to have a set time at 7 o'clock at night. But with younger kids, you can pick a time and try to do that. So you need to be creative. If you're not creative and you're not making reasonable proposals, that may be fatal to your case. Because if you're just going to say, oh no, I got to get my equal time in the summer and my equal time in March break, you're sending a message to the judge of how rigid you are, that you're not going to be flexible, you're not focused on trying to help the child have a relationship with that other parent. And I'll say this to the payors: there's case law that says if you're not paying child support or not paying it regularly on time, that goes as part of the best interest of the child analysis, that you're not focusing on the best interest of the child because what you're doing is you're ensuring that your child doesn't have funds to be able to live the way they should be able to live. So when you think that you want to oppose these kind of mobility cases, pay your child support, pay it on time, don't play games. I know there are payers that will intentionally play games because they're aware of the time period until FRO, family responsibility, will take until they start their enforcement process, and they'll always wait until the day before froze should start, and then they'll make multiple payments at one time. Well, you might think you're really being cute and you're driving your ex crazy, but then when your ex says, well, I'm moving, and you want to object to it, a judge is going to look at it and say, this person's a jerk, and they're not serious about wanting to co-parent. And quite frankly, if you're not paying your child support, you're only strengthening the argument of the move for the parent who needs to move for employment opportunities because they can't count on your child support. So what I'm really getting at is everything is case by case, but you need to look at yourself in the mirror and say, is my behavior that I'm demonstrating something that I would be proud of? That a judge is going to read it. How is a judge going to look at it? And I remember one time I had a friend of mine who's not a family law lawyer, and he asked the senior partner at a very large firm, how do you know if something is ethical or not? And the answer was, how would you feel if that ended up on your behavior ended up on the front page of the newspaper? Would you feel comfortable that you behaved ethically or not ethically? So those who want to move or those who want to oppose the move, well, this is going on. Realize you're under the microscope. And would you be proud of your behavior if there was a front page article in one of the major newspapers written about you, or maybe a high profile podcast that talks about you? How would you feel about that? Would you hold your head high and say, I'm proud of how I was? Or would you be embarrassed? And if it's the latter, don't do it because it may really hurt your case. Daphna, I see that we're basically out of time. I wanted to thank our viewers for watching. This is a really difficult topic and a difficult thing to be involved in if you're involved in a relocation case, because it's hard for both sides of the parents that are involved. And if you're looking for any assistance as part of your separation or divorce matter, or if it's a relocation case, feel free to contact us. Take a look at our website, separation.ca. You can call us at 905-415-1636. And the next Ask Andrew show will be on Thursday, May 1 at 12 noon. If you have any requests or ideas for future shows, please email us at info@feldsteinfamilylaw.com. Daphna, thank you, and thank you to our viewers for watching.